Right. I come to you first, Miss Farrington.
Yes.
Just to see whether there's anything that you'd like to add to the exchanges before we rose.
My Lord, no, I can update you. I've spoken to both the parents,
yes.
Just to explain what has been suggested. Both parents agreed to accommodation and had a discussion with Mr. Bain as well about suggestion of a narrative and also suggestion of what other services would be available going forward from the local.
So you've begun those?
We've begun those discussions, and we have agreed that potentially Tuesday, which your Lordship recognised was a day we were all supposed to be doing this case, we could perhaps have an extended sort of advocates meeting with Gwyneth.
Mrs. Justice Knowles was quick to spot this point. But I think that if you're not having a court hearing, you should still be paid for having a meeting. And so I think that the order that we would propose to you would be that the matter would be listed without the need for attendance at court, so that you were still a listed hearing within the proceedings.
Thank you very much.
It simply you wouldn't appear in court.
Yeah.
Sorry, would you close the door? Absolutely,
yes.
Tuesday is the obvious time to do that.
So that's really what we've been talking about outside the court, and I don't really have anything else to address.
Well, I'm going to come back to you in a moment with the product of our thinking, which I'll give you another opportunity to address. Mr. Bain.
My Lord, just to add to that, I think the meeting, I think the use of Tuesday, we're looking at combining both lawyers and the professionals.
Absolutely.
And family, obviously, the parents.
But I mean, I think it would be clearly a meeting gain something from everybody being in the same place.
Yes, exactly.
And making sure that nothing is lost, but it would be a matter for yourselves to, between you, decide where that should happen.
Of course.
As to what's the most convenient place for everybody, all things considered.
Thank you.
Right. Thank you. Well, now, what I'm going to do next is not to give any form of judgment yet, but to do sit down just to tell you what it seemed to us to be the product of this in terms of the outcome. What we would in the end be asking you to do is to send to this court by, we would suggest, 4 o'clock next Thursday, the 10th February, a draft order, the terms of which I'll come to in a minute, and something in the order of a page annexed to the draft order containing the headline products of your discussion. We are calling that in our own mind, as it were, an agreed plan for C's care. I don't have at my fingertips what this is called when it's not in the context of proceedings, but in the context of an agreed placement in foster care, but I'm sure that the regulations call it something, but basically to sketch out the main ingredients of that arrangement. The terms of the order would, it seems to us, be these, and I've so far got 4 paragraphs. The first is that the appeal is allowed. The second, that the findings of fact in respect of the mother are set aside. The third is that the local authority is granted leave to withdraw its application for a care order on the basis of the parents' agreement to Section 20 accommodation for C until further notice. And fourthly, that the hearing on the 8th of February is vacated on the basis that the parties
attendance dispensed with.
No, remains listed.
I'm sorry, the hearing on the 8th of February remains listed, but attendance at court is dispensed with. So that the parties are to meet. So the topics, it seems to us, for that, it's a process which will involve all the parties, not just those represented here today. So that includes the father as represented and C as represented and the guardian himself. That's for the formalisation of the Section 20 accommodation, because no doubt there are things that need to be signed and approved, and the creation of an agreed plan for C's care to include details of therapeutic child and family support. That within that structure, we propose to say very little, but something about our view of the reasons for granting permission to withdraw, and indeed for allowing the appeal, but those will be relatively minimal. They will seek to express what we understand the judge to have found in relation to the father, and they will give some views about the findings in relation to the mother. These will not be extensive remarks, but they will attempt to set the parameters for the discussions which will now take place, so that those discussions don't take place against a background in which just anything can be advanced because one or other party wishes to do so. So I don't think I need to go any further into that, because those views would be this court's views, but those will be, I hope, of some use to you when you're having your further discussions, and will give some indication of what our response is likely to be if we should meet any difficulties with the draft order when it comes to be filed. Because obviously we can't order you to agree draft order, but we will say that should there be any discrepancies between you in relation to the draft order, we'll expect them to be very crisply identified, and we'll deal with any disagreements fairly summarily without further attendance.
Can I say that's extremely helpful, and in fact, given the discussion we've had outside, all those items that we were discussing have been covered, and more, so thank you, my lord.
All right. Ms. Farrington, anything you'd like to come back on?
No, my lord, just to make it very plain that the mother really does hope that this plan that's going to be put into place is going to rebuild her relationship with C, and it's she very much hopes going forward that C will want to return home, but recognises that there needs to be a lot of work done. But I know that she would want me to express that today. I don't think there's anything else I can usefully say.
Thank you. Anything else, Richard? Very well. Well, in a moment I'll start judgment, but my apologies for some repetition from what we've just been discussing, but I think there ought to be one formal record of where we have reached at the end of this appeal. It's not necessary in the circumstances that have arisen to say anything about the history of these proceedings or the events that underlie them, because most fortunately, in our view, the parties who are represented here have been able to reach an agreed outcome which we're in a position to endorse. It's true that not all the parties are present or fully represented and present, but the opportunity has existed, and we see no reason not to proceed on the basis of the submissions and information that's before us. We propose to make an order disposing of the appeal and indeed these proceedings. We hope towards the end of next week, but will not do so today to give the parties an opportunity to do the necessary planning and discussion before the order is formalised. We will, in that order, firstly allow the appeal from the decision of the judge of the 9th of December 2021. Secondly, we will set aside the judge's findings under the threshold insofar as they relate to C's mother. Thirdly, on the application of Mr. Bain made on instructions of the group head of the local authorities services, we will grant the local authority leave to withdraw the underlying proceedings seeking a care order on the basis that the parents have confirmed that they agree to see being accommodated by the local authority under Section 20 of the Children Act 1989 until further notice. Fourthly and lastly, we will direct that the hearing on the 8th of February in the Family Court should remain listed, but that the parties are excused from attendance at court on the basis that a meeting of all the parties and their representatives will take place in order to finalise the future planning. And we would be grateful if the local authority would please notify the court out of courtesy that has happened. I would also be grateful if the local authority could forward a note of this short judgment to the judge so that he is aware of why the matter has been taken out so far as the court is concerned. I'd like to commend the local authority for its realistic approach to the judge's findings at the hearing today. The reasoning in the judgment did not seem to us to be adequate to sustain the threshold finding in respect of the mother in these most unusual circumstances. We also consider that the local authority takes a constructive position on whether it's necessary, proportionate, and in C's interests to seek to persuade us to remit the matter for further hearing. We will therefore be approving its request to be permitted to withdraw, leading to these proceedings coming to an end when the order is approved in due course. The only other thing that I would like to do is to make these remarks on the findings that were made at the fact-finding hearing, in the hope that they are of assistance to the parties in their discussion and form some sort of a basis for those who will be trying to help them in the future. So far as the findings made in respect of the father are concerned, there was some discussion at this hearing as to what exactly those were. It seems to us that what the judge was saying was that the father had on a number of occasions touched C in a way that made C feel uncomfortable, but that no sexual motivation had been established. No party sought to disturb that conclusion. So far as the mother is concerned, the judge placed emphasis on the recording made on the 2nd of December 2020 and on a number of matters recorded in case notes concerning the preceding days. I have to say that seen in calmer times, the mother's approach on this occasion seems to me to have been ill-advised. But it is of the first importance to see what happened over those days in the context of the painful predicament in which the family had been placed. And to set it alongside other evidence of positive interactions between the mother and C during that period. And alongside the judge's undoubtedly correct conclusion about the serious shortcomings in the local authorities' approach to the investigations. With regard to these threshold findings, we therefore consider that the local authority is right to withdraw its opposition to the appeal and to seek to withdraw its underlying application. In the circumstances that now arise, we have no hesitation in granting leave for that to happen, so that the urgently necessary therapeutic process can now be attempted. It's not possible to know what C's response will now be, but I hope that these events today can be the start of a process in which the parents and the local authority can now work together and that it might become the beginning of a healing process in this family.
I agree and have nothing to add.
I agree and have nothing to add.
Now, have we, Ms. Farrington, given you and Mr. Bain everything you need to progress the matter?
Yes, I think you have, my lord. Thank you very much.
Good. Well, we're not requiring that you delay until 4 o'clock next Thursday. We'd be happy to receive your work before then, but please by 4 o'clock next Thursday, so that we still have fresh in our minds all the matters we might need if there was anything else required of us. But I hope you will be in a position to have a finalised order by the end of next week.
Thank you, my lord.
Thank you all very much.